My name's Nigel Smith and I'm a solicitor in the Families Department of Astle Paterson. Within that department we cover all aspects of separation and problems that are encountered when couples split up, be they married or cohabiting couples. And one of those areas, of course, includes dealing with children. Hopefully couples can resolve the arrangements for children by themselves, and indeed the court would like couples to do that. But in cases where that's not possible, then we can offer a full service as to applications to the court, helping draw up parenting plans, guiding you through the court process from beginning to end. Dealing with children is very emotional. It's an area of law where you really do need somebody that can guide you, that can hold your hand but be impartial and give you sensible advice. And that's something that we would be able to offer you at Astle Paterson.
My name is Lauren Jones. I am a family solicitor at Astle Paterson. So we generally offer a fixed fee appointment for all new clients. The aim is to obtain as much information as possible and to ensure all issues arising from the separation are discussed. The appointment generally lasts up to an hour long, and we will at least determine what it is we need to do and how we are going to go about doing it. In terms of bringing any information to the fixed fee appointment, you will need to bring 2 forms of ID with you and any important information you may have received, such as court orders or letters, or anything you want us to have a look at for you, then that's absolutely fine. So during the initial appointment, we will discuss issues concerning divorce with you. In April 2022, the law changed, meaning one party to a marriage or civil partnership can now commence divorce proceedings without needing to apportion any blame on the other. All that is required is a statement that the marriage is irretrievably broken down. Once the application has been issued, the other party will have 14 days to respond, and then there are 2 further stages which we can discuss with you during the fixed fee appointment. Whilst it has been made easier to apply for divorce, we would say that it is necessary to obtain legal advice before responding to any court documents. So we will discuss issues such as children matters. Some parties in a relationship may struggle to reach an agreement in relation to who the child lives with and how much time they spend with the other parent. At Astle Paterson, we can help you to reach an agreement, whether that is informally or by way of a written agreement. In some cases, parties may struggle to reach an agreement, or there may be safeguarding concerns to address. If that is the case, then it may be necessary for an application to be issued for a child arrangement order, but we can discuss that with you during the initial appointment if we need to. Often the main issue is division of matrimonial finances. The aim is to achieve a fair outcome between the parties. The starting point is to ensure that there is an exchange of full and frank financial disclosure. We do not need to see full disclosure during the initial appointment, but we do need to have an idea as to what your income and assets are to be able to give you some advice during the initial appointment. Often the main issue is the division of matrimonial assets. The starting point is to split the assets equally between parties, but there are some circumstances where the assets will be split unequally, which is usually to meet the needs of one of the parties. The advice that we would give in the initial meeting is to exchange full and frank financial disclosure before any terms of settlement are entered into. We will also discuss the best way to do that during the fixed fee appointment, and then have a discussion with you in terms of getting any agreement reached between you recorded in a financial order, which becomes a legally binding agreement. There is a lot of information to discuss and go through, but we are legally trained at Astle Paterson and we can help you through that process from start to finish. So often the main issues are children, finances and divorce, but we can discuss other issues during the initial appointment, such as occupation of the family home, perhaps one of the parties' behaviour, or any prior agreements entered into. So whatever it is, we can discuss any issues that you may have during the initial appointment. So after the appointment, there is no obligation for us to do anything, and if you want to go away and have a think about how you wish to proceed, then that's absolutely fine. However, the advice would always be to open a file to start the ball rolling. At Astle Paterson, we do understand that separating from a partner, whether you're married or not, can be overwhelming, so we are here to support you legally and emotionally, so please do not hesitate to get in touch.
Hello, I'm Jane Fleming, a Senior Associate Solicitor in the Family Department at Astle Paterson Solicitors. Financial settlements are agreements reached between divorcing couples whereby they decide how they're going to split the assets between them. For example, there may be properties, there may be pensions, there may be savings or other investments or business assets that they may wish to share between them. And a financial settlement is an agreement setting out how these are to be divided between them. There can be orders such as property adjustment orders, whereby one spouse may transfer one property to another and provide a lump sum for their share, or it may be a pension sharing order where a proportion of one party's pension is paid to another as a pension credit and then forms the pension in their sole name, or it might be a lump sum payment or a spousal maintenance payment. When deciding a divorce settlement, you do not always have to go to court. More often than not, parties will settle matters outside of the court arena. So you can either decide it between yourselves or instruct lawyers to negotiate on your behalf, or alternatively, you can go to mediation, which is something the court would expect you to do in any event before making an application to the court, in the hope that matters can be settled without the need for court proceedings. You may be worried about attending court if there is no other option but to start court proceedings. The first hearing is usually by video link, so you do not have to even go to the court building, and all parties and the judge will be on the screen in front of you during that hearing. At the second hearing, parties normally are expected to attend court and negotiate a settlement with the help of a judge. At that hearing, you will go through security initially, and then there'll be a waiting area where you wait and negotiate there before seeing a judge, and then possibly negotiate after the hearing also, in the hope that you can reach an agreement. If no agreement is reached, the judge will list the matter for a final hearing, which you will have to attend, and evidence may be asked of you before a final order is made. When parties reach an agreement, they enter into what is known as a clean break consent order. This will set out the agreement reached between them, and it will be in full and final settlement. Without such an agreement, both parties are at risk of further claims. Say, for example, if you transferred the house but did not enter into a clean break consent order, and then you got divorced, you went your separate ways, and then several years later, your ex-husband or ex-wife comes to your door and says, well, actually, I'd like to now make a claim on your house or your pension. If you do not have a clean break consent order, then they can still proceed with that application. If they have remarried, they would be barred from making an application, say, for any pension claim. So it is extremely important that an application for a clean break consent order is made, even if you have no assets, as you do not know what you may accrue in the future.